Hello, I'm pleased to welcome you to the third seminar of Schwegman, Lundberg, and Woosner's Life Sciences Seminar Series. I am Nicholas Lenzatella, your moderator for the series. During this series, attorneys from the SLW law firm having a background in chemistry or biology will present on various topics in the life sciences in patent law. The seminars will be given on the second Tuesday of each month. If you attend 3 or more of these seminars live, we will send you a free gift. As a reminder, nothing in today's presentation should be regarded as legal advice. If you are seeking legal advice, please consult your legal counsel. I'm pleased to introduce our speaker for today, my colleague, Ricardo Moran. Dr. Moran's practice focuses on chemical and pharmaceutical intellectual property law, including preparation and prosecution of patent applications, infringement, validity, patentability, and due diligence analyses and opinions, and counseling of clients. Ricardo earned his bachelor's degree in chemistry from Allegheny College, his master's degree in organic chemistry from Emory University, and his Ph.D. from the University of Maryland, College Park, and his law degree from the American University, Washington College of Law. After receiving his Ph.D., he worked as a postdoctoral fellow at the Pennsylvania State University. The title of Ricardo's presentation is Obviousness-type Double Patenting from In Re Zickendraht to In Re Cellect and Beyond. Go ahead, Ricardo.
Thanks, Nicholas, for that kind introduction. Michelle, there we go. So as Nicholas so kindly noted, I will be talking to you about a topic that is near and dear to my heart. I know some people might think I should get out more, but it's a topic that I've been thinking a lot about recently. And as you will see, there's been some recent developments that some of which could have changed the landscape in patents for the worse, in my opinion. Let's go to the next slide. So as Nicholas mentioned, we're going to be recording this webinar so that if you cannot attend live, then you can view it afterwards. If you have any questions, we will ask that you please put them into the Q&A box located on the ribbon on the bottom of this presentation. And of course, you can follow us in LinkedIn and other social media as shown there. Next slide. So this is a good time to do a few thank yous. First off, I would like to thank Nicholas for being the mastermind and actually the driving force behind this seminar series. I know that it takes a lot of work. I also wanted to thank Michelle Forsberg and Sydney Polsky for all their help in putting this webinar together. Next slide, please. So this ODP topic is a very timely topic because there's been a fair amount of developments in the past year or so. The first case one of the cases that we'll talk about today is In Re Cellect, which came to be back in 2023, and it was followed just this summer by Allergan. At the same time, there was some proposed rulemaking, which would have been very bad, just to be brief there. In a nutshell, the rule would have made patents unenforceable, patents tied by a terminal disclaimer unenforceable if one of those patents were held to be invalid, either at the Federal Circuit or at the USPTO. Next slide. Thankfully, about a few days ago, almost a week ago, we found out, thankfully, that this rule was withdrawn. And so, I'm thankful primarily because we don't have to worry about, one holding of unenforceability infecting an entire patent portfolio. Next slide. So the agenda for today is to explore the origins of the doctrine of ODP, some strategies for addressing these ODP rejections, and a review of some judicial recent developments. One of the things that I wanted to, one of the reasons why I wanted to start at the beginning is because I was faced with what seemed to be a 20 or 30 way double patenting rejection. And I kept writing in various instances my typical response. The claims X, Y, and Z have been rejected under the judicially created doctrine of obviousness-type double patenting over claims P, D, and Q of patent or application number X. And so I started thinking, well, where did this come from? Like when, the judicially created doctrine, where did it begin? And so if we can go to the first slide, it began back in around 1963, where an examiner had rejected claims that were not patentably distinguishable from claims in a patented prior art from the same inventor. In the end, the judicial opinion held that the claim should have been rejected for double patenting. And Judge Rich articulated that the double patenting rejection could be avoided or disposed of by filing a terminal disclaimer. And so that's one of the things that we typically do. And as you'll see in some of the tips that I suggest, that is one common technique. It's the easiest, but as for reasons we'll talk about, people should think twice about filing a terminal disclaimer, especially if that rule had come to become a rule, then this would, filing a terminal disclaimer would people would really stop to think about that. Next slide. And so after Zickendraht, we have just some cases that refined the language around the double patenting rejections and basically led to the distillation of the language so that patent examiners have a nice form paragraph that they can include in their office actions. Next slide. So when can these ODP rejections arise? And as we just discussed, of course, during prosecution. And as I was going through that rejection that I just mentioned about 20 or 30 different patents, we'll talk about how I was able to dispose of that in various different ways. But one of the things to keep in mind is that ODP is an affirmative defense during litigation as well. So that's the other instance when it comes up. Now, I don't have statistics on the invalidation rate for ODP, and that's a pet project of mine. But as you can see here, giving credit to IP Watchdog, they have compiled some PTAB invalidation rates. They are alarmingly high. And so, I'm going to be very curious to see what the final number is when I finish that project. Next slide. You can move on to the next slide. So why is ODP so odd? Way back when I was starting my practice at Foley and Lardner, I first came across one of these ODP rejections, and I thought to myself, man, why do I have an ODP rejection over a later filed patent or application? And it just perplexed me. And so as you can see here, the filing dates do matter. So a later application or patent can be used as a basis for ODP for an earlier filed application or patent. And so I didn't know that at the time, but over the years, of course, I've come to know that, in some cases, painfully know that. Um, One of the things that you should be aware of, especially if you are dealing with university clients and their spinouts, the startups that spin out of various universities, is that you can, some of these ODP rejections can include patents from different assignees, and that can be very problematic, as you might imagine, especially if the university and patent assignee might not be playing very nicely in the sandbox. So it might be difficult to overcome, if not impossible. One other thing that makes this ODP odd is that if the first patent has expired, a terminal disclaimer cannot be filed, and the second later patent will be invalid for ODP. So, practice tip, you really need to keep an eye on all your patent portfolio and make sure that just make sure where every single patent lies in time, and be careful that you don't have something expire that would later lead to an important second patent being held invalid for ODP because the earliest patent is no longer alive. Next slide. So the standard for ODPs are, again, something a little esoteric. Claims of a second patent or application are not distinct in view of the claims of the first patent or application. The most common test is the one-way test. And so that just simply asks, is the claim at issue patentably distinct over the reference claim? We're going to talk a little bit about the two-way test, which is rare, but this is something that is important. And if you are one day faced with a situation where there might have been, you might have filed claims in one application that couldn't have gone into a second application, and there was an administrative delay by the USPTO, then you might be able to rely or push the examiner to do a two-way test. As people on this webinar are well aware, a lot of what we do is, or a lot of what the U.S. Patent and Trademark Office does, it's just burden shifting. And so they just push everything over to us to address once they have met that burden. And this could be a really important tool for you because, as the next slide will show, the two-way test basically forces the patent examiner to do a obviousness analysis in both directions. Patent application or patent one, is that, or those claims obvious over the second patent application or patent, and then back the other way. Okay, and so that places a higher burden on the patent office, and it's not until it's, as you can go to the next slide, if either analysis does not lead to a conclusion of obviousness, then you are in good shape, right? No double patent and rejection of the obviousness type is made. So one benefit of this two-way test is it reduces the risk of invalidity under ODP when the claims are merely related but not actually obvious variants. Now, one of the things I should mention here as we go through some of the practice tips is that sometimes I struggle as to whether what is the best way to get around an ODP rejection. Am I doing the right thing by trying to overcome it? Should I do a terminal disclaimer instead? Because you never know what's going to happen down the road if you find yourself in litigation and the patent is held invalid under ODP. would it have been better not to put in anything into the record? Should I have filed a TD? Thankfully, so long as that earliest patent is not dead, then I can still file a terminal disclaimer. Next slide.
Ricardo, we have a question here.
Yes.
The question is, what happens when the patent tied in a terminal disclaimer is abandoned or expired after all are issued?
Well, I mean, I guess it depends, right? Because if that's that was the reference patent, then the other patent to which it is tied will also expire. So the standard for ODP, same thing as Section 103, except that the first patent or application is not considered prior art. And then, one might ask, well, under which circumstances can the reference to the under which circumstances can you access the specification? Because remember, when you are dealing with obviousness-type double patenting, you are dealing with claims to claims. Okay, it's always a claim to claim comparison. And the patent office should not reference the specification of the first patent or application, except maybe to, for claim construction or understanding what the terms in the application or patent mean. The other thing to keep in mind as we go through these particular sections of ODP, primarily, the one-way test and the two-way test and the standards, I am condensing hundreds and hundreds of pages in the MPEP into a few different slides, and condensing a ton of information, because as folks know, if you look at the section on double patenting, it's huge. Not only does it include a ton of legal discussion, but it also includes a ton of charts and charts and tables that you use to determine whether an ODP rejection is proper. Okay, so I don't mean to mislead people here by condensing such a large amount of information into just a couple of different slides. So next slide. So again, as a practitioner, I sometimes struggle with how I should address a ODP rejection. And of course, one way is to preempt it. So just a little bit on the 121 safe harbor, that's the section of the patent code relating to divisional applications. And that particular section of the patent code was developed so that applications with claims to various different inventions that are restricted out are not subject to obviousness-type double patenting. And so one of the best things that you can do is to force a restriction requirement so that later you don't have to deal with these obviousness-type double patenting rejections. Now, as we'll discuss in a moment, one of the things that you have to be careful of, though, is suppose that you have an invention directed to a composition of matter generally, and then another invention to a method for using that composition of matter, and a third invention, a method of making that composition of matter. You get a restriction requirement and it says, hey, choose one, because under the patent statute, you get one patent per invention. And you have to be careful once you've chosen that you maintain those three different things separate. All patents relating to the composition of matter should be kept separate from all patents arising from the method of making lineage, and then separate from the method of using lineage. Because if you start mixing and matching, what you might find yourself, say you try to, say if you find yourself mixing and matching, you could lose that consonance that gave you the safe harbor in the first place. Now, one of the things that that people might not understand immediately is what happens if you get a restriction requirement. And typically people might consider leaving those claims to the various different other inventions in the same application with the hope that the examiner at one point might rejoin. Okay, so for example, you might leave the method of using the composition of matter in the same application as the composition of matter, with the hope that the examiner might rejoin the method of use claims along with the composition of matter. And why would you do that? That is financially, it makes financial sense, of course, from an economic standpoint. You would be paying for one less issue fee, one less maintenance fee. And let's face it, if you have hundreds of patents in your portfolio to various different inventions, and you have to pay all those issue fees and all those maintenance fees to just as an example, that's a lot of money. Okay, so some clients decide, I would like to get as many inventions into one application as possible. Okay, but one of the things that you might consider, though, is that you might consider canceling the claims to the other groups of inventions, because if the examiner rejoins, then basically you don't have any safe harbor anymore, because everything is in one application. And now you might file some continuations, or if you file a divisional, you should be fine. But if you file a continuation to a refinement on the composition of matter, you might tie, basically you're mixing and matching there, and you might tie your continuation to your first patent. And so that's something that you should consider that you want to do. Now, one of the things that you should also be careful of, and this is more of a strategy, sort of a tool to keep in your back pocket. There are situations where an election of species requirement can act as basically as a restriction requirement to create the safe harbor between claims in one patent over those on a related patent. Okay, and that particular factual scenario is very, very specific. So if you read St. Jude Medical, what you'll find is that it is so fact specific that it is likely that only under those facts will you be able to rely on election of species as creating the safe harbor. In that case, generic claims were never presented. And so the restriction requirement was just an election of species. And there were several of those. And so in the end, this 2013 case held that an election of species, when there are no generic claims presented originally, then can act as a restriction requirement where a safe harbor can be created. Next slide. So another way that you handle ODP, okay, so the previous slide was just preempting it. So doing whatever you can to foreclose an ODP. Now, what happens if you find yourself with an ODP? And what do you do? Of course, you can argue, for example, that compound claims, compound claims are distinguishable from other compound claims, but that's always a tricky situation because you will be arguing over your own patent. And, ever since I started practicing 25 years ago, I quickly learned that I don't want to be saying too much or putting too much into the record about my how how certain things in my patent application or patent that issued, let's say 5 years ago, is patentably distinct from something that I'm claiming now. Okay, um, because a lot of that will be held against you if those patents are ever litigated. One peculiar thing, and again, in the spirit of like, why is ODP so weird? Okay, is that for compound claims you cannot rely on lead compound analysis. Okay, and again, it's like I don't know that you would want to, even if you could, because as folks know, the lead compound analysis sets forth a compound where the skilled artisan would have started as a lead compound. Maybe it's a compound that has high activity, and maybe it's a little bit different than the compound you're now claiming. And then they would have used that as the springboard to modify that compound and eventually arrive at the compounds you're now claiming. Okay. Again, I wouldn't want to argue that over my own art, unless, of course, I didn't really care too much about this particular line of cases. Evidence, but on the plus side, evidence of secondary considerations can be considered in an ODP analysis, and that's great. I think that again, that is probably a much safer situation, especially if you have a compound that just surprisingly, I don't know, maybe it has a longer residence in your bloodstream and a higher AUC, but it doesn't get you into a situation where it is toxic or something like that. So those would be the sorts of secondary considerations that you could introduce in an ODP analysis. Now, another way of overcoming an ODP, and this is, remember what I said at the beginning, is one of the things that started my interest in putting this presentation together, was that I was working on a 20-way ODP rejection, where there were just a ton of patents and patent applications that allegedly rendered the instant claims obvious. Okay, and so I started parsing through it, and one of the things that you can do in situations like that, of course, is to prepare a table. So I put all these into a table where I had the patent number, patent application number in one of the columns, and then the subject matter claimed in a second column. And remember, ODP is a claim-to-claim obviousness analysis. And so it became clear that, the claims that I had been advancing related to, for example, chelated radionuclides in a molecule. And some of the patents, or a large number of patents, related to similar molecules, but in this case, they were to optical imaging agents. Okay, and so it became very clear that there really was no overlap in the subject matter that I was claiming. And so as I went through all this, I think the picture that emerged is that I could isolate a lot of the patents into a bucket that I could easily distinguish as not overlapping at all, and at least argue that one thing wasn't the chelated radionuclides are not an obvious variant, okay, of the optical agent. The other thing that became clear is that there were other patents that I could argue about just based on the subject matter. And then the third bucket, if you will, was the one where you would find patents that it was arguably okay to file a terminal disclaimer. And so we'll get to one more practice tip, I think, in the next couple of slides. Michelle? Where if you have a situation where the only remaining rejection in an application having the earlier patent term filing date, if the only rejection remaining is an ODP rejection, then you can rely on a section of the MPEP that stands for the proposition that you should allow that application to move forward and patent. And then in the other applications, so, for example, if we have a parent-child relationship, you might, and the only rejection that is present in the parent is an ODP rejection, you would ask the patent office to let the parent proceed without a terminal disclaimer, and then, or just to remove the ODP rejection and just make it in the children, okay? And that's just a quick way to dispose of an ODP rejection. You might ask yourself, well, why would you want to do that? It's just going to be, they're going to hold it in the children, and you're going to have to file a terminal disclaimer in the children. Well, not necessarily. Because again, one of the points that I'm going to continue driving home time and again during this presentation is that ODP is a claim-to-claim comparison situation. Okay, so you don't know what the claims in the child 1 and child 2 application are going to look like ultimately, and maybe they're going to look significantly different than in the parent. Let's say, for example, you change things drastically in one part of a molecule, or there's really no overlap in the scope of child 1, so that there may not be a terminal disclaimer. So this is a good way to just kick the can and then fight another day. And so these are some of the situations where you might overcome an ODP just by relying on the rules set forth in the MPEP. Next slide. It occurs so far we have discussed 2 ways of avoiding an ODP rejection. The first one, of course, is the forcing of a terminal, not a terminal disclaimer, of a restriction requirement in one way, shape, or form. The other way is, for example, arguing the ODP rejection on various grounds. And of course, the at least apparently easiest way to overcome ODP is by filing a terminal disclaimer. And as folks know, if you file a terminal disclaimer, you're agreeing that the expiration of the reference patent or application will be the same over the reference patent. I'm sorry, whatever application, the ODP rejection and whatever it's tied to, they're going to expire on the same day. Okay. You also agree that there's always going to be common ownership during their common patent term. Now, that doesn't mean that you can't license the application separately. It simply means that the two patents tied, or two or more patents tied together via a terminal disclaimer, are always going to be co-owned. And if that co-ownership is severed at any point, the patents will be unenforceable. Okay, so that's one of the things that one really needs to keep in mind as you proceed. I mean, people might not, well, people might not think to look, oh, wait, it's like, are these patents tied together through a terminal disclaimer? And you might end up selling one patent right and keep one patent right, and that will create enforceability problems. And of course, I wouldn't foresee that happening very easily, primarily because people are careful. And one of the first things that we look at least at SLW, when it comes to due diligence, is terminal disclaimers, ownership issues. And so that's a very important piece that you have to consider: the ownership, the common ownership issue. Next slide. But of course, things in life aren't that simple. Sometimes what you'll find, and as I talked about earlier, what if you have a situation where, I don't know, a company, a startup, has some relationship to another company or university. And, it's not uncommon, for example, that you have inventors filing on a patent application and getting a patent while they are working for a university. And then the inventors form a company, and that company is spun out or formed separately from the university. And then the inventors keep inventing, as inventors do. And what that can create a situation, of course, where you might have an application in question or a patent in question and a reference patent that are held by different assignees. And that's really not an uncommon situation. And it's a situation that I've run into a fair amount in the past 2 or 3 years. That can create a situation, especially if, for example, company 1 and company 2 might not be playing very nicely in the sandbox. And so, it's going to create a situation where maybe, the patents people are very reluctant to assign patents from company 1 to company 2, just so that a terminal disclaimer could be filed. And again, this brings up and underscores the common ownership issue that you really have to keep an eye on. And of course, that I don't think that it can be understated is that what if you have a significant amount of patent term adjustment on an application, and then all of a sudden there's an ODP rejection, and you end up having to, I guess, face at least the decision of filing a terminal disclaimer and cutting off all that patent term adjustment. I mean, that's a big consideration, right? Let's say you have 1,000+ days of patent term adjustment. You can significantly reduce that by filing a terminal disclaimer, and that can be very important because especially folks who practice in the pharma space like I do, sometimes the really serious economic windfalls come towards the very end of the patent, at least because for pharma, there's a fair amount of marketing that goes on, and the drug has to be adopted, and there's so many different considerations that with basically place that economic windfall at the very end of the patent term. Next slide.
Ricardo, we have
Yes.
an interesting question here about co-ownership. Now, if it's too complex and you want to research this first before you give an answer, consider that. But the question is, if the co-ownership is severed, but later fixed to be co-owned prior to an enforcement action, does the period of separate ownership still prevent the patents from being enforced due to the terminal disclaimer?
That is a really good question. That is a great question. Unfortunately, the answer is I don't know. I don't know, and that is something that I would like to look into. And whoever asked the question, I think if you give me a little bit of time, I would love to be able to just correspond with you on this, because that's a great question. Something that I haven't run into.
Here's another interesting question. Imagine a situation where you're prosecuting a patent and maybe you should have received a double patenting rejection. There was no restriction requirement, and your claims are very similar to the claims of another family member, but no obviousness type double patenting rejection was received. Now, in that situation, would you ever recommend or consider filing a terminal disclaimer sort of sua sponte to proactively inoculate against a later invalidity obviousness type challenge to the patent?
That's another great question, but this one I think I can field. Okay. So under these facts, right, an ODP rejection wasn't made. Okay. Now, if you are still under prosecution, okay, and this is actually a situation that I have run into in a slightly different context, is actually more of an obviousness context. And of course, there's probably going to be a lot of hand wringing, and you say, well, should I somehow contact the examiner and say, hey, listen, you should have made this rejection. I'm not sure that that's I would never, I don't know that I would ever recommend that. Of course, that could be an approach. But, at the end of the day, I suppose that there is nothing that stops you from filing a terminal disclaimer, period, right? I don't think that I have seen any requirement that you must have an ODP rejection in order to have a terminal disclaimer. But that part is something I'd have to look into, because I haven't done it and I haven't run into it. But keep in mind also that let's just say these 2 or 3 patent patents move in their merry way. So long as the earliest of say the reference patent is the earliest, the one with the earliest date is still alive, you can always file it at some other time, right? During litigation or just before litigation, right? Because there's a lot of thinking that goes on. There's a lot of strategy that goes on behind the scenes before anybody goes into litigation, right? And this would be probably one of the calculations that people would make. Are these claims so close that someone will, because it's an affirmative defense, someone will say these claims are invalid for double patenting. So that's something that you can definitely think about. I'm not sure that, to finish the thought, I'm not sure that I would do it by prompting an examiner, because you can't really control what happens at that point. You don't know what the examiner is going to say on the record, etc. Yeah, so I think it's something that you could do either after the patent's grant or during the prosecution. I can't think of a reason why you can't file a terminal disclaimer without an ODP. So now we're going to go into the last portion of today's talk. Well, actually, can you go back one, Michelle? Yeah. Judicial developments. As from the outset of this webinar, I referenced In Re Select, which came out last year. It expanded ODP. And then this year, this summer, of course, Allergan came out and it interpreted In Re Select. I'm not sure that I'm going to get into the grim details of what happened in each of the cases. Just to give you a preview, I will go into In Re Select and just talk about some of the high level issues and the ramifications of those issues. But I will go, because I'm an organic chemist and I'm a pharma practitioner, I will go into a little bit more detail in the Allergan decision. So next slide. So In Re Select came out last year, and there was a buzz about it. And at the time, I just didn't appreciate what the buzz was all about. And I sat through a couple different presentations on In Re Select. And even then, I was just like, I just didn't grasp what the big deal was. Okay. But it became very clear to me as I kept mulling it over and reading and rereading the decision that really at the center of this is that before In Re Select, PTA wasn't considered as an extension of patent term in the context of ODP, but In Re Select made it so. Okay, and so everything revolved around this 036 patent, which received no PTA. And so the argument was that, all those other patent applications or patents there should have been a terminal disclaimer because it was an extension of obvious variants of the 036 patent. So next slide. So later expiring patent can be held invalid for obviousness-type double patenting. Really, this where In Re Select can be boiled down to in view of an earlier expiring commonly owned patent, even if the later expiration date is solely due to patent term adjustment. Okay, and so now there's just one more thing we have to consider as practitioners. It's like how does the PTA affect it? How does this factor into the ODP analysis? One of the other holdings or thinking that came out of the In Re Select case is that patent term extension was separate and not considered for ODP. And that's a great thing because, again, as a pharma practitioner, patent term extension, which results from regulatory delays for a particular drug or for a particular drug, for example, is not considered for ODP. And so everything is good. Okay. So In Re Select expands the scope of potentially invalidating prior art. Okay. Because all of a sudden, all these other patents that previously you wouldn't think of, they're all in the same family in one way, shape, or form. But they all expire or technically would have expired on the same day, but for PTA, now are considered as invalidating prior art. Okay. Interestingly, and again, this just goes back to the notion that ODP jurisprudence is something that we all as patent practitioners should keep an eye on, because it's still developing, and these are some sweeping developments. And so the Supreme Court denied the petition for cert just in October of 2024. So that's a big development, because at least the Supreme Court's not going to be weighing in, at least not in this case. And as we know, and this is my own opinion, every time the Supreme Court seems to get involved, things get, as they say in Minnesota, interesting. Next slide. So then came, right after In Re Cellect, came Allergan. And this is the sort of the patent landscape for Allergan. You had this 356 patent that had received 467 days of PTA. So it expired later than the two other patents shown here, the 011 and 709 patents. And the one thing that to keep in mind here is that the 356 patent emanated from an earlier filed, earlier patented, and then a later expiring situation. Okay, 011 was filed after, as you can see from the not much after, but after the 356 patent issued, and it patented later. Same thing with the 709 application. It was filed after the 011, and it issued just shortly after the 011 application. So next slide. So the one thing to keep in mind, and this actually should point to the 356 patent, the arrow. The 356 patent claim that was asserted was claim 40, which related to the compound shown, elaxatiline. I probably mispronouncing that, but we'll go with it. Is the compound, the generic term for it, and Viberzi is the branded name. And it's used to treat diarrhea and abdominal pain in adults with diarrhea predominant irritable bowel syndrome. Okay, so IBSD. And the thing to keep in mind is that claim 40, or that the claims of the 356 patent, were the first instance of the patenting of this molecule. And so, that turned out to be an important fact here, is that, it's an earlier granted patent on a novel and non-obvious molecule. Next slide. And then the thing to keep in mind is that claim 33 of the 011 patent, it was directed to a method of treating pain or gastrointestinal disorder using elaxatiline. And here we have two very different types of claims. You have one to a compound, the other one to a method of using that compound. Next slide. And then you have the 709 patent, which was filed much later and granted later, which has a claim 5 to elaxatiline. Okay, and so, what's interesting about this, just in retrospect, is that we have two compound claims and one method of using claim. And just in my experience, the method of using may not necessarily just doesn't generally render the compound obvious. Okay, and so I think in this case turned on the fact that elaxatiline was it was a novel molecule that patented in an earlier filed and earlier patent application. Next slide. And so Allergan limited the application of ODP that came out of In Re Select. The holding there is, as I've been stating over and over again, is that a first filed, first issued, later expiring patent cannot be invalidated under ODP by a later filed, later issued, earlier expiring reference patent claim having a common priority date. But we have to be careful is that, you know, you have to read the opinion, and you'll arrive at the thinking is the fact that, you know, the first patent really had claims directed to something that just wasn't obvious over the method patent, let's say, for example. So that the fact that the 356 patent expires later is of no consequence here, because it is not a, quote, second later expiring patent for the same invention, okay? Next slide. All right, so at this point, I think what I'd like to do is I would like to thank you for listening to me for almost an hour about a topic that I really enjoy learning more and more about. And again, I would like to thank the folks who made this possible, Nicholas Lanzatella being one of them, and of course, Michelle Forsberg and Cindy Polsky for really supporting us through this process. Thank you.
Nice job, Ricardo. I thought you did a good job fielding those questions. And there are no further questions. You've answered them all in the middle of your presentation.
Nice.
So if anybody has any additional questions, feel free to send those to Ricardo. Slides for today's presentation are available in the chat or will be emailed to you as a link. As just a reminder, the SLW Life Sciences Series seminars are held on the second Tuesday of each month, and the next seminar is currently scheduled for Tuesday, January 14th. So I hope you'll tune in for the next seminar. Thanks so much for your attention today.
Thanks, Nicholas.